May I please, madam?
Yes.
Madam, this appeal was admitted on 7/5/2025, madam.
Yes, what is the stand of the respondents? He's claiming that the private respondent number 6 to 11 are below him.
Yes, my lord. Yes, my lord. That was the case in my writ petition, my lord.
Huh.
But since, my lord, they have been, my lord, upgraded in the year 2013, the petitioner did not press for the interference.
Did
But-
not?
The petitioner did not press for the interference of this upgradation. But since, my lord, the petitioner and the writ petitioner is senior to all of the respondent in the writ petition, my lord. So he need to be, my lord, upgraded as done in the case of, my lord, all the respondents, my lord. That was the prayer in the writ petition. And, my lord, after hearing the writ petition, the single judge, my lord, has, my lord, allowed the writ petition and directed the respondent, state respondent, to, my lord, accommodate the petitioner, my lord, as and when the vacancies arises. There is nothing wrong in the, my lord, judgment passed by the single judge, my lord.
No, my lord, direction was there, my lord. My lord, he is to be appointed within a period of 2 months, my lord. Our contention is that, my lord, there is no such vacancy, my lord. A direction has been given to appoint him, my lord, within a period of 1 month.
How, from where do you show that there is no vacancy?
My lord, in our affidavit, my lord, we have stated, my lord, the affidavit filed by respondent number 1, the
No,
chief is,
But that's only a statement.
yes, ma'am.
Where is the list of posts and the person in,
My lord, that was, my lord, not,
showing of the person in,
my lord, that was not placed before the, my lord, learned single judge, my lord, in the affidavit also, my lord. In fact, my lord, his name appears at the seniority list, my lord. As
just show the man in post and the what you call the
deployment list, my lord.
number of posts available and men in posts. Show that.
But then I will file an additional affidavit showing that, my lord.
No, then also it will be a case only for extension of time to appoint. Otherwise, we don't find any reason to interfere with this order. Okay, we'll give them time.
But
My lord can see the hardship, my lord, of the petitioner, my lord,
No, but
although
if there is no post, we can't direct, it is not implementable order.
so if there is vacancy, he will be benefited, my lord. So I may be allowed to file one additional affidavit, my lord.
Many. Huh? Bring to the-
Prospective से चाहिए,
my lord, in that case, my lord, since, my lord, they are not disputing that, my lord, I am senior to all the private respondent, my lords. It is admitted fact that, my lord, the petitioner in the writ petition is senior to all the private respondent, my lord. Only the problem, my lord, what my learned friend is submitting is that, my lord, the department now, as of now, my lord, do not have vacancy, my lord. In that case, my lord, may I pray that, my lord, this appeal may be disposed of directing the respondent as and when a vacancy arises, my lord. Petition should be placed first, my lord.
We'll
Before-
consider that.
Ar-
But we have to know what is the position. As and when, supposing, as and when happens after 10 years, then,
That, my lord, they will not do, my lord, because
no, we are just asking you a question. As and when, if it happens after 10 years, then what?
Then, my lord, it will be the hard luck of the petitioner, my lord. But, my lord,
Don't want the orders of the court to be non-implementable.
Be-
Non-implementable order is bad in law. It's a paper degree.
my lord, there are many, my lord, contingencies in the queue, my lord. And many of them are, my lord, the
That's what we are asking you.
blue-eyed men of this.
That's what we are asking. We are not interfering with the order. We are just asking you what happens. There should be some time for implementation of the court's order. Now, supposing we dismiss this appeal, then what happens? How does it benefit you?
My lord, then in that case, my lord, the order of the, my lord, single judge will, my lord,
But only when there is a vacancy. We can't order to create post that is within outside the domain of the court. Then
that is true, my lord.
both sides are represented. Mr. R. Saikiel, and standing counsel for,
No,
Therefore-
standing as well. My lord, they have engaged me, my lord.
Learned counsel for the appellants. Grace is granted 2 weeks' time to file an affidavit to brief on record the number of posts in the cadre of
WC, my lord. WC Khalasi, my lord.
WC Khalasi,
In my lord,
showing also showing the man in position. First off, the affidavit shall be sworn and filed
my lord, he is presently under the Upper Siang Circle, my lord. And the appointing authority is the superintendent engineer, my lord.
Acha. Will be filed by the superintending engineer of
My lord, Upper Siang Basin, my lord. Upper Siang Basin,
Upper
in-
Siang
Basin,
Basin
my lord.
of Department of Hydropower Development, Government of Arunachal Pradesh. List after 2 weeks.
Can it be my 3 weeks, my lord?
Okay, 3 weeks.
Okay, my lord.
My lord, till such time, my lord, I am, my lord, told by my client that, my lord, this trade test is being conducted even during the pendency of the writ petition, my lord.
Please repeat again. We did not get it. Please repeat again.
My lord, I have been told by my client that trade test has been, my lord, is conducted even during the pendency of the writ petition, my lord.
What has
See-
been conducted?
Trade test, my lord, for upgradation to WC, my lord, in the department, my lord.
Fresh test.
Trade test for
Trade
upgradation,
test.
yes, my
Okay,
lord.
Trade test.
And my lord, even department might, my lord, this conduct this trade test during the pendency of this writ appeal, my lord. So that may be, my lord.
But you have to make a prayer. You file an application. Consider that.
Okay.
Next para. Before the last line, you say that the learned counsel for the petitioner has submitted that as per information received by instructions received by him, the respondent authorities have conducted trade test for appointment to the post of
Conduct करेगा.
WC Khalasi. If that be so, the respondent would have is at liberty to file an appropriate application. List after 3 weeks.
Okay.
Obliged.
Item number 2.
May I please your option, madam? This writ
Yes.
appeal, this writ appeal is preferred against, my lord, the impugned judgment and order dated 12/6/2025, Annexure 10, by the Honorable Single Judge. On the last occasion, two occasions, my lord, the Standing Council was directed to produce on record whether there was any post existed at the time of transfer of my client. Whether there was any post, existing post of DTO, District Treasury Officer, at Longding, where I was transferred by impugn order. Our whole contention before the single judge was the honorable single judge was that there was no any existing post, and that was also observed by the court. They also filed affidavit admitting that position. They said, my lord, sub treasury officer was upgraded, but that is under the consideration of the government. No sanction order was issued. Court has accepted the position. Court said that yes, there is no any existing post, but that doesn't cause any prejudice to the petitioner. Therefore, the settled position of law is that, my lord, there cannot be any transfer against a non-existing or subordinate post or any post which is not equivalent to the post which I held at the time of transfer. So on that occasion, court was pleased to direct the government Standing Council to produce on record to apprise the court whether there was any post at the time of transfer. And I don't know whether they have obtained instruction or not. And on the that part, court was pleased to consider my prayer for interim prayer. Last two orders.
Yes.
So, Lordship, actually, I was directed to take instruction as to the status of creations of the additional post. This treasury officer, Lordship. On that particular point, Lordship, the instruction has come, Lordship, that is still under process before the government for creations report, Lordship.
No, but why for such a small thing you need so much of time? Why an affidavit cannot be filed? Whether there is post or not, it's as simple as that.
Lordship, here, Lordship, matter can be, otherwise it can be hard, Lordship. Why I'm submitting, Lordship? Here the creations of post is one thing, Lordship, and the working place, this is a posting place. This is completely different, Lordship, concept, Lordship. Here, Lordship, the post where the petitioner has been transferred, Lordship, that post has been, that office has been upgraded to the treasury office, Lordship, district treasury officer. Once it has been upgraded, Lordship, it has to be manned by the treasury officer, and the petitioner is the treasury officer, Lordship.
Petitioner is?
Treasury officer, Lordship. If Lordship come to the page 100, Lordship.
Yes, Mr. Prakash sir, please start your submissions because Mr. Tapin,
My lord.
is ready for
No, my
hearing.
lord. That's right, my lord. My lord, once the court intended to know whether there was any sanction post at the time when I was transferred, they have to produce on record that particular, my lord, instruction.
Just a
If there is
moment.
no sanction post, whether they, what is the meaning? my lord?
What is your position? You are holding what post? Your substantive
was
post is.
initially, I was initially appointed against the substantive post of district transport officer, my lord. At a district treasury officer.
District Treasury Officer.
Right. And I was transferred, my lord, against a non-existing post with the additional charge of sub-treasury officer. That was, my
Which
lord,
page?
pointed out before the
Which
court.
page? Which page?
My lord, Lordship, kindly see at page 107 of the judgment. That was, my lord,
81.
Impugn transporter is 81.
107.
107 is the finding of the court.
No, 107 is a part of a letter.
No.
Writ appeal 34. Page 107
Yes.
is part of a letter.
I'm just a minute, my lord.
Judgment.
Judgment. 107, next page, 107 of the appeal memo.
You have given two page numbering for both the honorable judges. My brother has a different page numbering. I have a different page
My lord,
numbering.
My lord,
So
extremely
we'll
sorry,
never
my
be
lord.
at the same page.
My lord, sorry, my lord.
What is the date of appointment order?
Appointment
find it
order is, my
ourselves.
lord, initial appointment. Initial appointment order is, my lord, 31/3/2009,
Page 65.
page 65.
5, 2009.
Yes.
Your name is Sering Norbu,
Yes,
appointed as Treasury Officer.
that's not.
Yes. Then,
Then, my lord, transfer order was issued subsequently, my lord, in 2024, page 81,
Annexure 8.
annexure 8.
annexure
8.
8.
8.
Yes, I have given the type copy, my lord. Next page. 81A. Transfer order is 24/7/2024. May I read, my lord? In the public interest of public service, in the interest of public service, Governor of Madhya Pradesh is pleased to order the transfer and posting of the following finance and accounts officer and treasury officer as shown in the following table with immediate effect. Number 1, Norbo Kiring. I was transferred from Tawang to Langding with additional
Yes.
charge of STO.
Yes.
Now they are saying, my lord, that basic, my lord, kindly have a look, my lord, their affidavit. The short affidavit they have filed, they themselves admitted that the question is whether there was any post or not.
Case number 98.
Page 98. Page 98.
From 2, para 5.
From para 5. May I read, my lord?
Yes.
Para 5. That the Longding Sub-Treasury Office is no longer a Sub-Treasury Office, but has been upgraded to District Treasury Office. High Government Order dated 6/3/2020. However, in view of the upgradation of various Sub-Treasury Office to District Treasury Office, the post of Treasury Officer are lying vacant, and an appropriate steps have been already initiated for upgrading and creation of post
Treasury officer.
of Treasury Officer, and same is under active consideration. Therefore, my lord, in view of that particular statement, my lord, everybody will understand there is no any sanction post. Post is not yet created by the government. Therefore, where is the scope for you in violation of FR 15 when I have a substantive right to hold lien against my substantive post? How can you transfer me against a non-existing post? Now, my lord, whether this particular finding was, my lord, accepted by the court, or my lord, that particular statement was accepted by the court. Kindly have a, my lord, kindly have, my lord, come at page 107.
Para 9.
My lord was pleased to record the submission made by the standing council. At page 107, para 7, my lord, last part of the para 7. May I read, my lord? They said, my lord, therefore, although the post of treasury officer is yet to be sanctioned in the district treasury office at Longding, there is no illegality in transferring the petitioner to district treasury office at Longding as treasury officer. What does it mean, my lord? How can you say, how can you justify that there was an existing post and no government servant can be transferred against a non-existing post? The settled position of law. Then para 10, my lord, what is the findings of the court?
Yeah.
Para 10. May I read, my lord? The petitioner has been posted at Longding, which was won by the sub-treasury officer before its upgradation. The district treasury office, Longding, would be held by the treasury officer, although, that part is important, although no sanctioned post of treasury officer exists at the time of transfer of the petitioner. No post exists, my lord. There is the funding of the court. The sub-treasury officer having been upgraded to a district treasury officer. And they say, my lords, upgradation is yet to be sanctioned by the government
In the affidavit.
in their affidavit. And my lord, assuming for a time being, my lord, if the sub-treasury officer is upgraded, then what is the occasion for you to, my lord, to assign the, my lord, duties of sub-treasury officer in addition to duties of sub-treasury officer? Sub-treasury officer upgraded. And court observed that, my lord, kindly say, then again, my lord, sub-treasury officer having been
Just a minute, sir. Just
upgraded to district treasury office, it cannot.
Yes.
Yes, my lord. Now, again, I'm reading, my lord, that part of the findings of the honorable court. Para 10. Although no sanction post of treasury officer exists at the time of transfer of the petitioner, the sub-treasury office having been upgraded to district treasury office, it cannot be said that the petitioner has been transferred and posted to a non-existing post. That part, my lord, of the findings, we are agreed by that part of the findings. Then kindly, my lord, have at page 109,
Yeah.
108, para 14. In the present case, although the post of treasury officer at district treasury office is yet to be sanctioned,
Para 14.
para 14, at page 108, is yet to be sanctioned. On its upgradation, the office would be manned by treasury officer, which the petitioner has been transferred without deprivation of any benefits, including status and other service conditions. Observation of the court is that since I was not prejudiced because I am getting salaries, therefore, whether salary is sufficient, my lord, if there is a degradation of rank, grade, status, then again, my lord, at page.
Para 16.
16.
Para 16.
Para 16, at page 109. May I read, my lord? It is observed that dismissal of the writ petition, present writ petition, rejecting the claim of the petitioner would not be construed that an employee can be transferred and posted to non-existent post as the present petition is dismissed on its attending facts and circumstances. Therefore, court himself observed that there cannot be any transfer. From this particular observation, it shows that, my lord, court accepted the settled position of law. Even then, my lord, writ petition is not maintainable because I was not prejudiced. That was the findings. Therefore, my lord, I raised a positive and specific question whether it is the privilege of the government by exercising its wisdom to transfer a government employee against a non-existing post. And if it may not permissible, then what about my right under FR 15? My right to lien, to hold lien will stand terminated. Will stand terminated. And that aspect was not considered. And once there is a positive findings of the court that, my lord, it is not permissible for the government to transfer the government employee to a non-existing post. But even then, the writ petition is not maintained. And on this occasion, two decisions were, my lord, placed on record. Both the decisions were, my lord, however, not considered by the court, saying that, my lord, it is distinguishable. And those two decisions, one is for Haryana High Court, another is for Bombay High Court. Both the decisions shows, it's subject to show that there cannot be any transfer against a non-existing post. And it was on that consideration earlier by order, it is 16. 16/9/2025, court was pleased to direct the government to produce in record whether there was an existing post at the time when I was transferred. And the said order was again, my lord, confirmed by next order dated 3/11/2025. This is the position, my lord. Let them produce on record, my lord, there was an existing post.
Okay. Yes, Mr. Tapin.
Lordship, just let's have a relook on the entire case, Lordship. Here, Lordship, the concept of the post and the posting place, Lordship. When the post is sanctioned, Lordship, it's not sanctioned against the particular Lordship area. And even if the if one is appointed in a particular Lordship post, he's not appointed in against the particular place, Lordship. So, for the creations of the post is concerned, that's at the discretion of the authority, as per the administrative exigency, how much posts are to be created is up to the government, Lordship. Once the posts have been created, and where they have to be, Lordship, transferred, Lordship. For that, another administrative order is there, Lordship. That is the designated, Lordship, the working place. Here, Lordship, what happened,
I'm just trying to understand.
Lordship?
There is a officer who is holding a substantive post of, say, superintendent of police.
Lordship.
Now you transfer him from particular district to a particular police station where there's a post of only in charge of the police station to be manned by inspector. Can you say that the person is holding the post of superintendent of police is getting a salary of superintendent of police, but he will work as an OC of the police station?
No.
I'm just testing that.
That is not case here, Lordship.
Okay.
That is not the case here, Lordship. May I take Lordship to the page 100, Lordship?
Page.
Page 100, Lordship. 100.
Yes.
This is a notification dated 6 March to 2020, Lordship. Long time.
Something wrong in the page numbering. It's
यहाँ पर प्रिंसिपल पॉलिटिकल बना हुआ
6th March 2020. Okay.
6 March 2020, Lordship.
Yes.
This is the Lordship government notifications, Lordship. I'm taking Lordship to the port paragraph. Further.
Yes.
Further. The governor of Arunachal Pradesh is pleased to accord sanction for upgradations of the following 9 existing sub-treasury to district treasury. District treasury. And Lordship will find at serial number 7. Serial number 7 is Longding.
Yes.
It was earlier sub-treasury office, Lordship. It has been upgraded to Longding, treasury office Longding. In second, third and port column, Lordship will find earlier it was STO, sub-treasury office Longding, and it has been upgraded to treasury office Longding. Once this office has been upgraded, Lordship, it has to be manned by the Lordship treasury officer. This particular the officer, Lordship, the petitioner, read petitioner, his substantive post is finance and account officer, Lordship. And treasury office is the analogous post where they can be, Lordship, transfer, Lordship. Otherwise, his substantive post is finance and account officer, Lordship. In some department, they can be transferred as a, Lordship, finance and account officer. In some area, they can be transferred as a treasury officer, Lordship.
Please mute yourself, Mr. Purkasa. Please mute yourself.
Lordship, then I'm taking Lordship to the Lordship my affidavit. My affidavit is 8 page 96. It starts from 96, but relevant is the page 98, paragraph 5, Lordship. Yes, some misconception on the very wording of the affidavit, Lordship. But otherwise, the concept is there, Lordship. Creation of the post and the posting place. These are the 2 different concepts, Lordship. Which is being, Lordship, here, Lordship, mingle of. May I read, Lordship, the paragraph 5. The Longding Sub-Treasury Office is no longer a Sub-Treasury Office, but it has been upgraded to District Treasury Office by Government Order number so and so and so. However, in view of the upgradation of various sub-treasury office to the district treasury office, the post of treasury office are lying vacant. That particular office, Lordship, is lying vacant. The post has to be, Lordship, additional post has to be created.
The post of STO has been upgraded to TO or
TO.
new post will be created?
No. the office has been upgraded to Treasury Office Lordship. Once it has been upgraded Lordship, now total strength, suppose say earlier it was 10 Lordship. Once it has been upgraded, one more office has been upgraded, it has to be manned by the Lordship, Treasury Office, official Lordship. Then Lordship, once the working places have been increased, Lordship, then Lordship, definitely Lordship, it follows that Lordship, additional posts has to be created, Lordship. Until additional posts are created, Lordship, then among the existing strength, total strength, that adjustment has to be done by the government, Lordship. That is exactly what is being done in the present case, Lordship. The
Okay.
petitioner was appointed,
Last time we gave you an example of Superintendent of Police. Now
Yes.
we give you another example.
Lordship.
You see, in a particular place, there is a court which is a court of subdivisional judicial magistrate.
Lordship.
Now, a district has been created in that subdivision. And now this, you say that the office of this SDJM is upgraded to post of district, the court of district judge. Now the SDJM cannot be, the post of SDJM cannot be upgraded to district judge.
Lordship.
But unless there is a district judge post which is created, how will somebody go and join?
Lordship, here, Lordship, he has been transferred as a from the post of Treasury officer to Treasury officer only, Lordship.
But you are yourself saying that there is no post created.
No. Additional post are yet to be created, Lordship. As I have submitted, Lordship, earlier it was supposed, for example, total string is 7, Lordship, Treasury officer. Now the working places have been increased, Lordship, from 7 to 10, say. 2 more persons are required to man the offices, the increased offices, Lordship. For that, it's up to the government when to create this post, Lordship, so that these two places can be
No,
whole.
because we know from our administrative experience that a post of district judge, if it is not there in a particular district, you can't transfer somebody and bring it here because that post, it's not the post which can travel.
No, office is there, Lordship. Now it has been upgraded as a
It's also
Treasury
there.
Treasury office, Lordship.
In our case also office is there. You have created a district judge.
Lordship.
In Arunachal Pradesh, there are also 2 or 3, 2 in fact places where you have district judge for more than one district. Correct. Now, supposing another court, another district, a district judge post is created. From one center, you cannot send somebody along with the post. There can be anything.
Lordship, once he has been appointed as a Lordship finance and account official, Lordship, he carries along with him all the benefits that the post is attached
It's
with,
not a
Lordship.
question of benefit. If the post is not there, how can you appoint someone?
No, no,
You create
he,
a post.
because he was appointed against the sanction post only, Lordship. Now it's a question of transfer only, Lordship. Now he is being, Lordship,
Tell me, you explain me in a very easy terms. We have very limited administrative experience,
Lordship.
correct? So you must think that we don't know about administration. And then tell us, in the example which we are giving, first we gave the example of a superintendent of police, then we gave an example of a district judge. Can it be presumed that in a district when the post is upgraded, there is already a creation of the post? Can that creation of post be presumed?
Lordship,
That's what I was thinking.
Lordship, just here, Lordship, I'll cite one example of this very judicial Lordship. Here, Lordship will find in our state, basically, some office, courts have been upgraded as a district court, Lordship. And some have been, Lordship, as a CGM, Lordship. But still, Lordship, the judicial officer are not yet appointed, Lordship. But till additional posts are appointed, the existing officers, they can be transferred to that.
No, they hold circuit court. In this state, we have the sessions division, and there are judicial officers who for district A goes to that place and do it just like us. We come from the principal seat, hold the court here. The fact is that the posts are already created. It exists, and therefore, when we come from the principal seat, we hold our own. We carry with us our own post. So in circuit courts also what happens is that from one division, one district to another district when he travels, there he travels as a divisional authority and goes there and takes, because there's a notification that these two states or these two districts or these three districts would be under one sessions division. So in fact, he is the head of one sessions division and goes and holds court in another district, but he carries with him the authority of being a sessions judge of the division. A division may comprise of three districts. That is what our experience says.
Lordship, and it will amount to restricting the government from Lordship their authority
No,
to
but-
create the circle division.
But without post,
Lordship, it will amount to restricting the government.
definitely it has to be restrained. How can you create an office without an officer and then say the officer is transferred to that where there is no office, in fact?
Now, after the office has been created, only the post will be sanctioned, Lordship. That can be done. To my understanding, Lordship, that is
What is the difficulty of the state to do it? If they have the will, there's a way. By afternoon, they can create this post by 2 o'clock. You already have the order of creation of post.
Lordship, that's my humble submission, Lordship.
happens to
The
the
government has
SPO
always
Upon
discretion,
upgradation of that office to the office of a treasury office,
Lordship.
what happens to the post of STO? The STO post is upgraded,
Post is not up. It's still there.
still STO is
It's-
still there.
It's still there.
So the STO can hold the charge of, can be in charge TO or till the time
Till the time that,
a TO post is created.
that can be done, that's up to the government, Lordship.
But if a existing TO from another district is placed there,
Lordship. How
Then-
his service, how he is affected, Lordship? Question comes there. How he is affected, Lordship? He has joined already. He is getting his salary,
but
Lordship.
post is
He's
not there.
functioning as a treasury officer, Lordship. Nothing, no changes on his nature of duties and nature of benefits, whatever he's getting out of his substantive post. He's getting only there, Lordship. How he is affected, Lordship? To approach the court of law, Lordship, one has to satisfy the court that he has been legally prejudiced, Lordship.
Can you produce the salary slip of the appellant?
Lordship, that is not being, last time also this issue was raised, and that is not being disputed by the appellant. He is drawing salary.
It's not a-
Yes, I can, Lordship. I can, Lordship.
Whether they dispute or not is not the.
Yes. Definitely, I
We want to
can.
record our satisfaction.
Definitely, Lordship.
You get it by today, tomorrow we'll take it up.
Day after tomorrow, Lordship.
Day after tomorrow is again very difficult.
It's from the Longding, Lordship.
Oh, they can transmit it by email, by WhatsApp. We can look at your mobile and be satisfied.
Lordship. Tomorrow, Lordship, I'll try my best, Lordship.
Friday will be very difficult because we have to wind up everything and then put all the signatures and then go. We have our own difficulties on Friday.
Tomorrow, Lordship, I'll try.
both sides are represented. The matter has been heard in part. As Mr. S. Tapin, learned senior government advocate submits that notwithstanding the transfer of the petitioner, appellant, where no sanction post of treasury officer exists, but the petitioner, but the appellant is discharging his duty as a treasury officer without any deprivation of his status or emoluments. Accordingly, the learned senior government advocate shall cause production of a copy of the salary slip of the appellant through email or WhatsApp or any other electronic mode. Next para, list on, make it tomorrow. 13.
One thing, madam.
Hello.
May I point out one thing, madam?
Item number
Hello?
3.
Yes,
Yes.
My lord, may I just point out one thing, madam?
yes.
My lord was rightly pointed out. That has to be taken into consideration. My lord, STO office was upgraded. Post was not upgraded. Therefore, my
No,
lord,
let us
if
see,
the-
if you are getting salary as a treasury officer, then
No, that was
let
pointed
them
out
produce the
before.
document.
Yes,
Let
yes.
them produce the document, then we'll
No.
consider.
My lord.
All right.
Item 3,
Yeah.
this
No petitioner, yeah.
Yes.
petitioner.
Respondent.
My lord, as per the last order, the petitioners, they have been remaining absent since the last 3 consecutive
Today also
days.
they are absent.
Today also, man. And it's the SIC have filed their latest status also.
Where is the status of the status report of the construction?
Not the construction, my lord, the inquiry. Inquiry conducted, my lord. What happened in this case, my lord? Earlier,
No, the allegation is that the Department of Public Health has money was siphoned off from this department without execution of work.
yes, my lord.
So
This, initially, there was a writ petition file that was withdrawn, my lord.
Yes.
In the meantime, the SIC, they have already registered a case for inquiry. Now, after the writ petition was withdrawn, they again filed this PIL, my lord. In the meantime, the inquiry has already started and the inquiry was conducted. Prima facie, there was no anomalies found out. Now, only the technical part, the SIC as per this latest status report, they want,
No, we don't even have any document of the date of completion. Where is the document of
that is
showing date of completion?
exactly, my lord, the allegations have been made in the air. And they want a fishing and robbing inquiry to be
No, it's
conducted
okay.
by this honorable court.
It's okay, but please tell us, what is the date of completion of this 210 meter span bridge?
Councillor.
1020.
Page 15, my lord, it is their own,
They have given a statement of 18/5/2017 completion certificate. But it says this is a manufactured document. And then next part of the sentence, it says, the date of completion is shown as 31/3/2016 and 31/3/2017. For a bridge, how can there be two dates of completion?
my lord, this is with regard to the certificate issued, the experience certificate issued.
Correct.
The certificate is under inquiry, my lord. The allegation is false. Completion certificate has been issued, my lord.
Incidentally, come to paragraph 7 of your reply.
Reply of my lord, by,
Filed by officer in charge SIC, vigilance,
my lord.
paragraph 7. No, Mr. Radan, you will have to be very vigilant
Yes, my lord.
when vigilance is next to you.
Yes.
Yes. With regard to statement made in paragraph 7 of the PIL, the answering deponent has no comment to offer as the same are matters of record. So vigilance says that there are two dates of completion.
Yes, my lord. This is a matter of inquiry, my lord, by the vigilance.
No, inquiry is made, so why we should not interfere? Even if in a PIL, even if the petitioner is not there, you can still take it up.
Yes, my lord.
And can you come to the affidavit of respondent number 9?
Yes, my lord.
He's the assistant engineer PHE. Come to paragraph 8. Statement made in paragraph 7 are true to the best of my knowledge. And again in paragraph 3,
3, my lord.
it says paragraph 7, no comments. So in the same affidavit in paragraph 7, there is no comments. And in paragraph 8, it is true to the best of my knowledge.
It's not assistant engineer at time. Mr. Lincoln.
Your executive engineer who is in charge of the work, respondent number 14, he says no comments in his affidavit.
This, the allegation is made against one RN Singh, my lord.
No,
And
whatever,
this-
but it says, it refers to RN Singh is the executive engineer then,
Yes, my lord.
and this executive engineer comes and says there are no comments.
Yes, my lord.
There is a
He
petition.
cannot,
How can one bridge have 2 days of, it calls for an inquiry?
no, my lord, he cannot comment on what RN Singh has done, my lord. That is,
No. He has to. Now, I'm just giving a example. I'm good in giving bad examples. Correct.
Yes, my lord.
If you can tolerate this one, please hear us. We have, next item is a review item passed by an honorable judge who has superannuated, limited office. Can I say that, no, we review petition is of the other judge, we can't make any comment?
My lord, RN Singh is also a respondent out here, my lord.
We understand, but now
Here-
the executive engineer the executive engineer who's giving these comments, he is the person in charge.
My lord, if my lord sees, the allegation is that Mr. So-and-so has issued a certificate, fake certificate. That is the allegation. To which this answering respondent
No comments.
has no comments whether he has issued that RN Singh had issued or
To
not.
do that. Officer will say from records whether this completion certificate issued or not issued.
My lord, as per the SIT's report, no such document exists in department that it has been issued. Such fake document has been
Yeah,
issued.
the person who is in charge of that office is the custodian of the document. He doesn't say, he says no
Yes.
comment.
He cannot say because there is no such
No, he
document.
would have said that this doesn't exist. The document referred to in paragraph 7 does not exist. Why we should not order a fresh inquiry? SIT is apparently doing nothing.
RN Singh, respondent 12, who is the
Mr. Padak the vigilance, the highest police in the state, is doing nothing.
My lord, as for the status, my lord, no fake certificate has been found. We have seized the computer, my lord, and we have sent it for scientific examination. We have whether the roads and the bridge were properly built or not. We have asked for a.
So that means in your, all these 15, 16 respondents, nobody has the courage to say that statement made in paragraph 7 is false. All people, they don't have any courage. And you want us to rely on your submission. Is it so painful to say that no certificate was issued? Very painful. Our government has restricted the use of pen. That in one day, don't use more than half mm of ink.
Five, 6, 7. Or 8, yeah.
No, well, government can restrain people from misusing pen, writing many things, exposing things. So therefore, they will say that no, superintending engineer, executive engineer, they will not write more than this much. No.
My lord, in the affidavit of respondent number 5 and 6, my lord.
Five and 6.
Yes, my lord. Here they have.
Which page?
My lord, at paragraph 4, my lord, page 28.
This is 5 and 6. Is it which page?
It starts from, my lord, page 27.
7.
Affidavit in opposition, my lord.
5 and 6. Yes, you got it.
Page 20, para 4, my lord. With regards to the statements made in paragraph 7(1) of the PL, the answering respondent begs to state that the reference of work in completion certificate issued to MS Jumbliang Enterprises were checked from the office records and the details are mentioned below in table A. Tables have been given, my lord. Then name of contractor none, name of work none. These references of works orders were not issued to anyone as verified from the relevant records books. Then from serial number 9 to 14, these work orders were not issued to MS Jumliang Enterprises. My lord,
Where is the statement here that the same petitioner filed a writ petition and then withdrew it?
my lord, we have the earlier order, my lord. They have also. My lord, pen.
Is it the case of Ampalo Mina?
Yes, ma'am.
Yes,
That one?
Yes, ma'am.
yes. My lord, there are 10, my lord. It is their own statement in the PR.
Okay. Then you have been able to make out a difference. This affidavit somehow did not catch our eye earlier.
Yes, my lord. My lord.
Okay.
Allegations have been
None
made.
appears on call for the none appears on call for the petitioner. However, so and so, just give your names. Will record. So and so for the respondent number so and so are present. Next para. This court by order dated 4/11/2025 had recorded that the petitioner was absent consecutively on 3 last dates. After filing of the status report of the case. No, but was absent on call, that's all. So. Next para. The Mr. N. Ratan, you are appearing as in what status here?
Additional AG, my lord.
As
For
additional advocate general for the state.
One,
Submits that
two.
the petitioner had earlier filed a writ petition, which was numbered as WBC 226 of 2023, which was withdrawn with liberty to approach the appropriate forum. Full stop. Thereafter, the present PIL has been presented before this court. Next para. By virtue of this PIL, the petitioner, namely Sri Ampalo Mena, is seeking a direction upon the respondent authorities for an independent investigation and inquiry by the Central Bureau of Investigation in the matter relating to siphoning of funds to the tune of rupees 3 crore, thereby causing loss to the exchequer in the Department of Public Works Department, Rural Works Department, and Public Health Engineering Department. It is further alleged that no inquiry whatsoever was conducted against the hiring officials, despite existence of credible evidence against the concerned officials. Next para, the learned additional advocate general, by referring to the statements made in paragraph 7 of the writ petition of this PIL, has submitted that in respect of all the allegations contained in subparagraph Roman 1, TO2, Roman 7, the superintendent, the superintending engineer, BOLENG, civil circle, Yingkyong, YINGKIONG, division, PWD, within bracket response number 5, and the executive engineer, Yingkyong division, PWD, within bracket response number 6, by filing a joint affidavit in opposition, have responded to each and every allegations, broadly denying that the work under reference were issued to the contractors named by the petitioner. Moreover, it is submitted that as per the said affidavit, some of the alleged works which were allotted, which were shown to be given to certain contractors were not even issued to anyone.
Public Works.
To stop the description of each and every work through which funds were allegedly siphoned off are more fully contained in table A and table B. Table A, table B, and table C of the said affidavit. Next paragraph. The inquiry officer, special investigation cell, SIC within bracket vigilance, bracket goes police station. Had submitted a status report dated 21/8/2024. No, not this. Strike out that. Where is your affidavit? Which page is your affidavit, Mr. Pada?
Page.
The-
Opposition matter.
Yes. You just say that the Mr. Upadhyay, planning counsel for the SIC within bracket vigilance, Arunachal Pradesh, has referred to the affidavit in opposition filed by respondent number 10. Has submitted that upon receipt of information by the petitioner, following cases were registered, being number 1, SIC which VIG within bracket PS discrete inquiry number 7 of 2023 dated 14/8/2023, number 2 SIC vigilance VIG within bracket PS discrete inquiry number 8 of 2023 dated 14/8/2023. To stop thereafter, regular inquiry cases were registered by memo number. This you will get at page 11, pink flag. The second file, affidavit in opposition. Full stop. Be that as it may, it appears from this affidavit that the inquiry has not been concluded. And neither a positive report nor a final report has been submitted therein. It's not completed?
No, ma'am.
Next para, the such circumstances, comma. As the inquiry by the police is still continuing. And as major part of the allegations have been denied by the respondent number 5 and 6, comma, taking note of the fact that the petitioner is remained absent on the consecutively for 4 days. Comma, this PL stands dismissed for non-prosecution. To stop. However, comma,
Very fun.
so however, this dismissal of this PL shall not preclude the right of the petitioner to take appropriate steps as he may be so advised, depending upon the nature of final form filed by the SIC Vigilance.
Item number 4.
You have given your names. You have given your names.
They have given motion.
May I please, your losses.
Yes.
Madam, today, madam, in this matter, we have filed the affidavit of service to respondent number 4 to 8.
Where is that affidavit?
Only for 5. Huh? Well, this matter relates to
Just a moment. Let us see the affidavit of the service.
yes.
This respondent numbers, very unique feature in these respondent numbers 8 to 8, 9, 10, 11, 12, 8 to 12.
No, you're.
Oh, no, 4 to 8.
Yeah.
Very unique feature of these respondents. All their signatures are same. Just, Mr. Dhiram, just verify, we are not experts in signature.
We are on different station.
Just check out 8 to 7. Yeah. It would be very rare. 4 people having same signature.
I'm also not an expert, but it seems.
So far as respondent number 5 is concerned, I have received the Wakalatnama this morning itself. Others, I don't have any Wakalatnama. So respondent 5 has entered appearance, but he still yet to get the copy of the writ appeal.
So how notice was served without copies?
And well, petitioner has personally served with the help of lawyer.
And
They have solved.
the signature I have in Wakalatnama is different from there.
They're different.
Yes.
Shows that signature also.
You for respondent number 5.
5 only, 1 of 5.
Yes, Santosh. Santosh. Achha, while giving Dusty service, the registry does not give the copy of writ petition. Why does the registry allow that? We'll take up the matter in the administrative side. This can't be done. Notice without copy of the writ petition, that can't be processed and issued. That's the service. The writ petition is not there. And that's the issue. Without copy of the writ petition. Something wrong in the. No, along with Dusty notice. Why copy of the writ petition is not done? Because he's coming and saying that the writ petition will not serve. No, it can't happen. Might happen in the afternoon.
We host. That's the stuff.
Lordship, that might happen only in the case when one person received for all.
No,
Yes.
I don't know.
Yes.
They are residents
This
of the
affidavit
same
will have to
household.
Reject.
Another matter.
Different altogether.
Affidavit will have to reject.
Otherwise,
You have to take fresh steps for others.
For all, Lordship, because I have yet to get the copy. Copy of the writ appeal. I have also not.
Well, then, if your lordship allow, then I can serve him. No, he has appeared for the respondent number.
He's appeared for others, you have to take steps again.
In fact, he is representing for all others in the repetition, my lord.
Only for 5.
Speak to him. He says 5, you say for all.
No.
But he appeared in the rate petition for all the rate petitioners. So I don't know. Maybe he has different.
You file an application, interlocutory application to issue a mandamus to Mr. Saxena to appear. We'll pass orders.
Otherwise, we have served, but then maybe the one
No,
person
no.
had received for everyone. I think he put
Give
signature.
copy, issue fresh notice.
We can serve to the rest of the petitions.
But don't do like in this manner. And you know, your statement takes away the entire credibility of this affidavit. Although you may not remember innocuously statement made, but that destroys the entire fabric of your affidavit. You say that you went and served through your advocate, taking assistance of your advocate. That part of the story is missing in the affidavit. And now the question is how does the advocate know? Who is the person to whom the notice is to be served? Advocate will not know.
Yes.
Somebody must identify him.
Yes.
Now the affidavit doesn't say who is identified. That is why to accept a Dusty service, I am very careful. Sorry, you issue a fresh
Yes.
steps. For Mr. S. Mohan and counsel for the petition, for the appellants, as well as Mr. Y. Ram, then it commented with for respondent numbers 1, 2, and 3. Mr. K. Saxena and counsel enters the appearance for respondent number 5 and plays for some time to file his Wakalatama. Mr. B also plays for a copy of the memo of appeal. Mr. The learned counsel for the appellant shall provide a copy of memo appeal to the learned counsel for respondent number 5 within 2 days. Next para. In the affidavit of Dasti filed by the petitioner on 10/11/2025, as the persons receiving notice on behalf of the respondent of 4 and 4 to 8 has given a similar signature towards receipt of notice, the court is unable to accept the said affidavit as a proof of delivery of notice by way of Dasti on the respondent numbers 4 to 8. Next para, as respondent number 5 has entered appearance, the appellants shall take fresh steps for service of notice on the respondent numbers 4, 6, 7, and 8 by registered post with an AD. In addition, the appellants are at liberty to serve notice by way of Dasti by routing the process through the registry of the court. Next, the registry, while issuing notice, shall also ensure that copy of the memo of appeal is also enclosed there too. On service of notice, an affidavit of service shall be filed prior to the next date of listing. Next para, the appellants, the learned counsel for the appellants is at liberty to collect the postal receipt number from the registry and to submit postal track report prior to the next date of listing. Next para, awaiting service of notice list on 19/10/12/2025. Instead of registered post, make it speed post, not that circular. This now the High Court has issued a circular since there is no registered post. The reference to registered post will be speed post. So in the order, we are now saying speed post.
Well, in fact, this matter relates to basically at the beginning, your lordship passed the interim order, and that's how it went. And then the single bench was in against the petitioners. We are challenging a writ appeal. And what happened is that as per this respondent, especially the government, they are saying that compensation has been this one released. But then as per the interim order in the writ appeal, direction was that if the deputy commission has not released, then it should not be released. If it is released to the community, then also it should not be released.
But notice has not been served on respondent by it. That is the difficulty. That is why we had to search for this and.
Yes, but I will be praying for the interim. Interim is still today, because we don't know whether that whether money has been really released to the beneficiaries from the community. Now,
Okay.
Mr.
Interim order passed earliest and is extended to the, till the next date of listing. Mr. However, it is made clear that the interim order would be effective on respond number 8 from the date of service or notice. Okay.
Item number 5.
Chalna? Okay. Yes.
This is an appeal against a conviction under the POXO Act, Section 6 of POXO Act, and read with Section.
The submissions are almost finished now, madam. The learned friend, I understand, has already completed. As I was submitting earlier, madam, my case before the learned single judge was that my suspension itself was not any application of mine because there is.
That we have taken the point.
Yes. And now since your lordships are now, my lord has seen, the suspension order itself is under 371H. That could not have been done. And thereafter, the renewal orders are under CCS 10(6)A and B. If the suspension order is under 371H, how can the CCS, CCI rule now be invoked for renewing the suspension? So your lordships, my lord,
You
is
don't want
jurisdiction.
people to be wiser.
My lord.
You don't want people to be wiser.
But the fact remains, my lord, it was basically because there was a public hue and cry suspended. And kindly see, 4 years now. I have not been accused in any case, my lord. In fact, examination cell, I have been removed for, I have not been there since 2014. Just because there was some paper leakage that were done in so many selection processes, there was public hue and cry just because of that.
Okay. We close the matter. We'll just examine the records and pass judgment.
I'm just some. Since your lordships are even in division bench exercise 226 jurisdiction, my lord. My lord, when I have brought your lordship's notice, under what manner the order has been issued, your lordship will consider. 226, my lord, can go anyway.
The submissions of Mr. S. Tapin, Learned Senior Government Advocate for the appellant, and Mr. D. Panging, Learned Counsel for the private respondent. So there's only one respondent. By the respondent is concluded. Order reserved.
All other matters 7 to 9 are same. Only the post will be different, but everything else is same.
Okay.
That is how it has been done. One is my lord, stenographer, deputy secretary, stenographer, all treated the same.
Just write in a piece of paper.
Yes, I will give it. All right.
Item number 5.
Yes. Just wait, she'll come. She'll come, don't worry about it. We are extremely sorry. Those division bench matters took some time. Yes, Mr. Das.
My lord, I think today there is no time, my lord.
No, because there's a full court meeting at 4:45.
Yeah. My item number is 6.
Item number 6.
6.
But all this motion I attend maybe.
My lord, the roll for tomorrow, my lord.
When do you want? Mr. Das, when do you want?
Tomorrow, my lord.
Tomorrow, okay.
But all these motion matters maybe they roll
Okay,
up
motion matter,
All motions tomorrow.
all motion matters tomorrow.
Right.
And if in any case you have
All
some
motion tomorrow.
requirement of fixing a date, please tell the court master, she will confirm with me and give the date.
My lord. Item number 19, your lordship. Is tomorrow evening. It's on admission.
Item 19. Okay. 19 also tomorrow.
My lord, item number 15 to 17 maybe taken up on 26. 26. 26.
Those dates the court master will give. She will just consult with me and give the dates. Just write the dates and tell me.
Item 1, since your lordship will say, tomorrow, but I have a problem before. I just want to withdraw.
Huh?
Consulted with my client, I want to withdraw.
Item 1.
Tomorrow.
Okay. Item 1. Say Ms. N. Ranjan and counsel for the petitioner come upon instructions. Please leave to withdraw the writ petition. With liberty, no. With liberty to approach again, if so advised. Next paragraph. For government who will be there, you are there, Ms. P. Sangeeta, learned, government advocate is present. Matters are dismissed from withdrawal with liberty.
My lord, in item number 27, my lord, there's an interim order, my lord, that may kindly consider.
That will wait. 27 interim order. Fix it after when?
After check, my lord.
After 2 weeks.
Item number 25.
Yes, there's a person there, wanted to say something. Petitioner person is there, wants to say something.
Oh.
You want to say something? Me, sir.
Sir, I am actually with Das, sir.
Oh, acha.
We have a division bench matter, but we would request if my lord can
Division bench is not
list it.
there.
Not there.
Division bench is not there.
Sure.
Item